Thank you very much for this wonderful invitation and for those extremely, excessively kind words of introduction. I'm afraid this is going to be a very low-tech talk in terms of visuals. I have one website I want to show you in a little while. In the meantime, you can feast your eyes on the bridge, the old bridge at Chincoteague Island in the swing state of Virginia on the eastern shore, to which I'll be returning shortly to continue our get out the vote efforts. Anyway, so the golden tone perhaps gives me a little bit of a starting place, because we live in a golden age of fair use. Although this doctrine has been around as a feature of U.S. copyright law in one form or another, first as a judge-made improvisation, and later after 1976 as a statutory codification for something better than 150 years, it's really only now, and by now I mean in the last 15 or 20 years, that it's actually begun to amount to something, at least for people like us, for makers, for scholars, for a variety of practice communities around the United States and perhaps beyond, and I'll come back to the beyond at the very end of my remarks today. We've even had no less an authority than the Supreme Court of the United States generously recognize that fair use has a constitutional foundation. About the only good thing that can be said about the Eldred decision, or at least the majority opinion in the Eldred decision, is that it does recognize explicitly that fair use is one of the two major channels through which First Amendment values flow into copyright law, and that in fact, without it, this whole edifice might well be open to significant constitutional challenge. So this is good news, I guess, but it's not unalloyed good news, because in a real degree, all of the developments that I've just talked about, this little fair use renaissance, this new golden age, or whatever it is a reflex of some other much less salutary developments in the copyright environment: term extension, the multiplication of exclusive rights, the new gigantism of secondary liability, and so on and so forth. In most ways, in fact, in almost every way except this one, copyright law is actually becoming a more and more oppressive institution. And that's meant somewhat paradoxically, but significantly from the standpoint of this project, that fair use is today needed and recognized more than ever. Fair use has always been the, you could say, safety valve in the copyright system. It's always been the mechanism that relieves the pressure, the sometimes intolerable pressure that builds up as a result of the multiplication and ramification of rights claims. And it has an essential and unique role to play in the system today. And I'm searching for my cursor, which, when I find it, will permit me to continue. Sorry. So much for the good news, such as it is. Now, to be a little more technical. Both before and after the codification of the fair use doctrine in Section 107 of the Copyright Act of 1976, there has been a critique of fair use from various practice communities and experts associated with the interests of those practice communities, which I think is extremely important to acknowledge here. And that is that although the doctrine has potential, although its role as the safety valve in the copyright system is certainly one that should be respected, it's actually really tough to use. It's difficult to understand and to employ. This is what one might refer to as the curse of the four factors. As some of you know, when the Congress got around to codifying fair use in 1976, they drew on a lot of old case law and essentially instructed courts that in considering fair use defenses in the future, they were supposed to think about at least the four categorical considerations, which was very nice, but it didn't say how they were supposed to assess these considerations. It didn't say what weight the different factors were entitled to, and of course it didn't reduce the factor list. It didn't make the four factors exclusive, but left open the possibility that other considerations also might come into play. And justifiably, I think, in light of that codification, people responded by saying, well, theoretically this is very interesting, but we simply don't know what to do with it, we don't feel safe with it, we don't feel comfortable with it. And what I want to suggest to you today, and this sort of goes back to my original claim about a golden age or a renaissance or whatever it is that in the last 15 years, the landscape has actually changed very, very significantly. And now, let's again, fingers.
You can see it up here.
I know, but I can't see it here. That's the problem. And that's thanks to the widespread embrace by judges and courts, up to and including the United States Supreme Court, of the concept of transformativeness. Now, in essence, what this new bit of judicial learning, or relatively new bit of judicial learning, tells us is that where a new use of an existing work repurposes material for a new audience and adds significant value to it in the process, then that new use is likely to be considered transformative. And where that's true, where a new use is considered transformativeness, then in a sense the inquiry or the outcome of the general fair use inquiry becomes relatively easy to predict in a favorable way. What we've really done, or what the courts have really done with some urging and support from scholars, is to install a kind of meta standard above the four criteria that are given in the Section 107 statutory statement of fair use, so that where transformativeness is found, the other four factors tend to simply fall like dominoes. The nature of the use factor, the nature of the copyrighted work factor, the amount of the use factor, and of course the market effect factor are all strong, or the analyses of those factors are all today strongly, even decisively inflected by the determination of whether or not the use in question is a transformative one. I can talk later if anyone is interested, although it's kind of technical and boring, about how that is so, but I do want to stop and pause for a minute and talk about the relationship between the meta inquiry into transformativeness on the one hand, and the fourth factor, the market effect factor of Section 107 on the other. Because it is that factor which over the years has sometimes caused a great deal of concern about the indeterminacy and essentially the unavailability for many real-world purposes of the fair use doctrine. The fourth factor teaches that we need to take into serious account of fair use analysis whether or not the unlicensed use of the user and other uses like it, considered cumulatively, would have an adverse effect on the actual or potential market for the work. Now, if you think about that, that's an extremely expansive standard. And it means, among other things, that to a certain extent, if the unlicensed use were to proliferate, or uses like the unlicensed use were to proliferate, with the result that licensing revenues that would otherwise be available to the copyright owner for those uses aren't collected, then there's a fairly strong technical legal argument for the proposition that by definition, this important factor should count against the user. Well, what the courts have done here is to cut the Gordian knot. And what they've said, and they continue to say it in opinion after opinion, is that where the fourth factor is concerned, the copyright owner has no right, no expectation of monopoly rents with respect to transformative uses, or what is sometimes referred to as the transformative market. So think of this fair use renaissance as having two major pillars: the move to transformativeness, the rise of this meta-inquiry as a dimension of fair use analysis is one of them. And that's something that's been, scholars have made their contributions to it, but it's something to give credit where credit is due that has actually been driven primarily by judges who perceive the threat to discourse, the threat to innovation, the threat to creativity that hyper-copyright presents. The other pillar of the fair use renaissance is one that I think the scholarly community can actually take more credit for. And in fact, I want to give that credit where it is due to an individual whose scholarship has been absolutely central to the developments that I'll be describing to you in a moment, and to which Steve referred earlier in his introductory remarks. That scholarly contribution, the scholarly contribution that really has helped us to construct the other pillar that supports the fair use renaissance, is an article by Michael Madison from University of Pittsburgh called A Pattern-Oriented Approach to Fair Use, that by reanalyzing historical fair use case law demonstrates convincingly what some of us might have guessed before, but no one had ever had the sense or courage to pursue to a real analytic conclusion, that when they make decisions about what is and isn't fair use, courts defer to practitioners' views of what's reasonable, what's sensible, where the balance between protection and access should be struck. And when I say practitioners, I don't mean legal practitioners. I mean practitioners in the various fields of information practice in which issues about fair use do and will arise. Now, there's lots of evidence for this, and again, Mike collects it and discusses it very thoroughly in this wonderful article. Let me just mention a couple of obvious examples with which many of you will already be familiar. For decades, for instance, the periodical and book publishing industries have understood what fair use means to them. They have asserted their fair use rights aggressively, and in decision after decision, courts have deferred to the industry consensus about what constitutes good practice with respect to the unlicensed use of copyrighted material. Likewise, somewhat less visibly as far as the courts are concerned, but very powerfully nonetheless, the broadcasting industry long has relied on internal standards and practices to determine how fair use applies in that context, and to assure that broadcasters at every level, from networks to local stations, are able to take appropriate advantage of this pro-innovation doctrine. The question is how to bring the benefits that these well-established information industries have long enjoyed under fair use to other practitioners, and how to assure that the collective views of those other practice communities will have as much weight and command as much respect in judicial discourse as we have already seen the views of established commercial practice communities have commanded for years. And this is the place where Pat Aufderheide of the American University Center for Social Media and I, and many, many wonderful collaborators, a lot of whom are in this room today, have been trying to take advantage of the developing environment of fair use, of the rise of transformativeness, and of this central insight about judicial deference to practitioner communities' insights as to what constitutes fair use. This is not a scholarly project, what I'm going to be describing to you, strictly speaking, although we hope that it has roots in scholarship and that the parts of it that involve inquiry are conducted according to the best scholarly standards. But to confess, this is not a conventional scholarly project. It's one that seeks to combine sort of three different pots of insights. Some insights about what is happening in law that I've just described to you. Some insights that we've been working with various practice communities to develop about what their collective values around the reuse of copyrighted material are, and a set of wonderful insights that really Pat, more than anyone else, has brought to this project about techniques of community organization or community organizing and how those techniques can be employed to bring about real change in the world. The basic formula for this project is simple, although the execution of that formula in some cases is anything but simple. The idea is to work with practice communities, often where they exist, through their collective membership organizations, to determine what their shared values are around the transformative use of copyrighted materials, and then to publicize the results. The privilege, and it really is a privilege, of being involved in this work, in addition to being able to collaborate with so many wonderful and creative and effective people, is the privilege of being able to talk at length with people who are actually doing important information practice in the world about their activities and their values. And I can't really say enough for anyone who might want after today to consider getting involved in this work, and I hope some of you will. I can't say enough about how endlessly fascinating, inspiring, invigorating, uplifting those conversations are. They're interesting conversations in particular because within most of these communities, and I'm going to give you a few specific instances and examples in a moment, there turns out to be a mixture of attitudes. On the one hand, and this mixture, incidentally, is not, it isn't a matter of there being some members of the community on one side of the issue and another faction on the other. It really is much more a matter of most of these communities consisting of individuals who are themselves divided in their views. On the one hand, there is, in every practice community we've worked with, a high level of respect for copyright, even reliance on copyright, or a hope of future reliance on copyright to their own advantage on the one hand, and on the other hand, a recognition of the powerful need for access to copyrighted material if innovative and creative practices are to continue and flourish. So we began because it was the community with which we had, again thanks to Pat, the best and strongest connections at that time with documentary filmmakers. Our work, which started a little more than 4 years ago on the documentary filmmakers statement of best practices in fair use, this document was really, in a way, the proof of concept for this larger enterprise. We conceived of it at the outset as a document that would have multiple audiences. It would be a tool for filmmakers themselves, a way in which they could learn about fair use and what their community regarded as fair use. a tool perhaps indirectly for rights holders, so that they would understand that filmmakers collectively shared a set of values and were prepared, if necessary, to defend those values. A tool, if any cases of filmmakers who had relied on the statement of best practices and then been challenged by rights holders should ever come to court for judges themselves. There have been no such cases, I'm happy to say. And especially and critically, and I want to pause here and say a word more about this because it is so important, a tool for what has turned out to be perhaps the most important audience of all, that is so-called gatekeepers. This is a sort of coinage, a new term of art that we are using throughout this project, and I need to say a word about what we mean when we say gatekeepers. We don't, as is sometimes thought, mean rights holders themselves or the agents who represent rights holders. We mean instead various entities with which creative practice communities have to interact in order to do their work or to have their work seen, heard, or read. So if you're in an institution, a school or a university, then your administrators, the ones who make copyright policy for the institution, are gatekeepers, and the lawyers who advise those administrations are gatekeepers, and the poor librarians who are sometimes given the thankless task of enforcing those rules are gatekeepers, and so on and so forth. Filmmakers, to return to the first group of practitioners with whom we have the privilege of working, have their own gatekeepers, and they tend to be broadcasters, both public broadcasters and cablecasters, and to a certain limited extent, commercial networks, distributors, and of course, insurance companies. Because for a documentary film to see the light of day in any conventional distribution format, be it on DVDs or over the air, that film has to have a so-called errors and omissions insurance policy, and insurers have in general been the toughest gatekeepers in the system, the gatekeepers who have classically refused to ensure any incorporation of copyrighted material into a new work on the basis of fair use, and have insisted either that the material be eliminated, that it be cleared, or that the insurance policy be written with an exclusion so that it wasn't covered. None of those being very satisfactory solutions from the filmmaker's point of view. So I won't spend time talking to you today about the content of the filmmaker statement. Some of you may know it already, some of you can look at it if you like. There is a website from the Center for Social Media where we have collected all of the materials relating to this project and a variety of supporting and illustrative supporting materials and illustrative examples as well. If you're interested in this work, I would urge you to go to the fair use area of the Center for Social Media.org site, because it is the best place for one-stop shopping. In format, what this statement of best practices, like the others that have followed it, to which I'll refer in a moment, does, rather than tracking this rather confused, or at least confusing statutory formulation, the 4 factors and all of that, rather than talking about transformativeness even in so many words, what the statement does instead is to identify recurrent situations that come up in the practice of documentary filmmaking, to identify those to which the fair use principle is generally applicable, and to articulate some limitations on the application of fair use in those situations. So There is a principle with associated limitations about commentary and critique, and there is a principle with associated limitations about illustrative examples, and there is a principle about incidental capture, and there is a principle about the use of archival footage. And then there is a very clear, at least we hope it's clear, statement that, of course, the four principles and their associated limitations are not intended to exhaust the potential value of fair use to documentary filmmakers, but are meant to portray, just to insist again, because the actual nature of this is so important given the theory that lies behind it, to represent filmmakers' consensus views about what constitutes fair and reasonable practice in each of these recurring situations. So in November of 2005, 3 years ago, give or take, we offered this document to a waiting world, and we were unsure, to say the least, about what was going to happen next. We were committed to a pretty long, and we expected rather difficult campaign to bring about recognition and acceptance for the principles as articulated in the statement. And what happened instead was beyond any expectation that we could reasonably have had, and that is almost immediately from the date of release, the statement began to be adopted as a point of reference by a wide variety of different participants in the documentary filmmaking system. The filmmakers themselves, who flocked to it for information and advice, not about what lawyers thought, although the statement had been very carefully vetted by a number of rather tough-minded lawyers before it was released, but for information about what their colleagues, and especially their senior colleagues, thought. Programs of instruction for documentary filmmakers, both in the formal academic setting and in informal or less formal settings, also immediately began, thanks in part to the sponsorship of the statement by the University Film and Video Association, to employ the statement as a teaching tool. So a new generation of documentary filmmakers is being brought up with an understanding of fair use that is inflected by the statement. All good. Then, somewhat more surprisingly, broadcasters began to hop on the bandwagon, public broadcasters to begin with, and then subsequently, to a limited but still very real extent, cable casters as well, commercial cable casters. And then, somewhat stunningly, about a year out, suddenly the practice of the insurance companies began to change. Again, I could talk later about the actual dynamics of that as I understand them. But in effect, the quick story is that this is a very, errors and omissions insurance is a very small and competitive field. There are a limited number, some would say 5, some would say 6 underwriters who do this kind of insurance in the United States. These companies are seeking always essentially the same business and seeking to compete in any way possible on price, to a certain extent, and very much on the quality of service. Once one of these companies saw the light, so to speak, where fair use is concerned, the others quickly fell into line. So we now have a transformed situation where the practice of gatekeepers in this critical role, the insurance, in this critical position, the insurance companies is concerned. They have moved from essentially refusing, except in very, very exceptional cases involving extremely high-profile prominent filmmakers, to insure any fair uses, to ensuring fair use routinely on the basis of the principles of the statement as supported by a letter from a qualified attorney. So this is a really, really big transformational change. And happily, there are also a number of outfits around the country, including the legal clinic that I run at American University and the wonderful legal clinic here at USC, where filmmakers who don't have great means can go to get the advice and eventually the opinion letters that permit them to obtain the insurance that makes it possible for their work to be seen. Big, big changes as a result of the influence, the power, the persuasiveness that the document turned out to have with the various gatekeepers involved. So we were emboldened by this. We felt that maybe after all, remember this first statement was the sort of proof of concept, as I said earlier, that maybe we were actually onto something. And our next outing was a little different. That was the work that led to, and again, you can find all of this documented and explained on the website, the Code of Best Practices for Fair Use in Online Video. Let me say one thing about all of these codes and statements that I'm going to be describing, and that is that, as I said earlier, although this is not a scholarly project, we do hope that it has a real scholarly foundation. Each of these statements was preceded by an information gathering phase, interviews with a wide range of practitioners, and each of those information gathering activities produced a report. So there was the Untold Stories report that preceded the Filmmakers Best Practices, and the predicate to the online video code of best practices was the Recut, Reframe, Recycle report, with which some of you may be familiar, again, available on the website, and which documents, as well as we were able, the problems and frustrations that online video makers were having with the increasing demands for copyright compliance, especially on the part of their gatekeepers, who were, to some extent, institutional, to the degree that the producers in question were located in institutional, for example, academic settings, and in part consisted of the proprietors of the various online platforms where user-generated content or online video is made available. So we had a conceptual or a sort of methodological problem, not a conceptual problem really, but a methodological problem with this statement, and that is that the field of online video production is sufficiently new and sufficiently diffuse so that it was hard, in fact impossible, to work on this statement through, as we had done with the documentary filmmaker statement, a network of national membership organizations representing the producers in question. Those organizations really don't exist. So instead, recognizing that the result was going to be something which was perhaps more provisional or transitional, but recognizing also that the need was urgent, we chose, in this case, to work instead with legal experts, including Jan Urban, and cultural studies scholars, including Mimi Ito, who had a rich and full understanding of the critical players in the system, the makers in particular, and their attitudes toward copyright and fair use. And the document was released in January of this year, and I think you'll be hearing later, perhaps from Francesca, among others, about its reception. I think the jury is still out on how effective this document will prove to have been. And the testing of it is going to come as the content owners on the one hand and the large UGC platforms, including YouTube, but not limited to YouTube on the other hand, work out their controversies both in the courtroom and outside the courtroom. it's pretty clear to me, unfortunately perhaps, but inevitably, that we are going to see, as a result of phenomena like the Viacom litigation, a new order emerging with respect to both filtering and takedown of online video content. And although all the participants in this system, the platforms on the one hand and even the content owners on the other, talk a relatively good game about the need to respect fair use, there is a real risk, the risk that Fred Malone has referred to so eloquently as the tuna dolphin problem, that in the effort to achieve efficient mechanisms for filtering and taking down commercial content that is being reposted on UGC sites, fair use videos, transformative videos may be a kind of incidental casualty. And although we're pleased that the Code of Best Practices for Online Video has received some attention and interest on the part of the maker community, the real test in the sense of its utility will be to see how much help it is to the relevant gatekeepers, in this case the UGC site proprietors, in defending fair use in their dealings with corporate copyright owners. We're hopeful, but the outcome remains to be seen. We have, however, moved on to another project, and this project I can only talk about a little bit because the document actually is yet to be released. If you come back to this site on November 11th of this year, you will see posted for the first time, and it will have been released that day at an event in Philadelphia, the Code of Best Practices for Fair Use in Media Literacy Education, which we've been working on now for about a year and a half, Pat and I and our wonderful colleague Renee Hobbs of Temple University. This is an attempt to deal with, to intervene in, let us say, one of the most difficult and complicated fair use environments, that is K through 12 education. For those of you who don't know, and I didn't know until very recently, the discipline, the field of media literacy education is one that has been around, depending on who's counting and how you're counting, for 2 or 3, or some would say even 4 decades. And it consists of all of the practices, some of them occurring in sort of dedicated course settings, and many of them distributed among a variety of different courses in history classrooms and social sciences, social studies classrooms, and especially in English classrooms. All of the places in the K through 12 curriculum where teachers work with students to help them understand how media makes meaning. Sometimes through analysis, and sometimes through practicing production techniques, not so much in order to learn to be professional video makers, but to understand by actually constructing a beer commercial how beer commercials influence or attempt to influence the market of underage drinkers, for example. This is actually a big deal in the K through 12 education community. There's lots of it going on. Many state educational standards actually prescribe media literacy education in the distributed form that I've just been describing as an essential part of curricula. Many teachers engage in these activities, and as the Cost of Copyright Confusion report, the precursor report for this particular study, again available on the website, illustrates, this set of practices occurs today in an extremely adverse climate where the understanding and application of copyright is concerned, which is partly a function of the kind of nature of gatekeepers who flourish in the K-12 community and the nature of their understanding, or as the case may be, lack of understanding of copyright principles. There's a big irony here, which you all will immediately appreciate, and that is, we all know, especially if we've studied the history of fair use, we know even if we've simply read Section 107, that education has a special privileged place in fair use analysis. So much so, in fact, that over the 150 years that we've had fair use and the 200 years that we've had copyright, educational uses have almost never been challenged by rights holders. But the irony is, perhaps because there have been so few challenges and therefore so few decisions, teachers and schools feel uncomfortable with fair use and are therefore reluctant to employ it. So this code, which says exactly the same format as the ones that I've just described to you, it states the application of fair use in a variety of different situations in which both teachers and learners make use of copyrighted material in the media literacy classroom, employing copyrighted materials in media literacy lessons, employing copyrighted materials in media literacy curriculum development. I'm just reading you the principles here. Let's see. Sharing curriculum materials, student use of copyrighted materials in academic and creative work, and audience development for student work. Those are the 5 areas in which the code states principles. The code is an attempt by a segment of the education community, and we have on board for this, crucially, a number of high-profile national educational organizations in which media literacy educators and others actively participate. This is an attempt by a segment of the K-12 education community that relies vitally on access to media content to establish their and their students' entitlement to use that content. There are going to be challenges for this new document, and I know where they're going to come from, at least in part. We've discovered that the K-12 community is a very, especially at the administrative level, a very bureaucratic and risk-averse institutional environment. And it's one where, unfortunately, an awful lot of rampant misinformation about copyright in general and fair use in particular now prevails. The gatekeeper problems are going to be severe precisely because there are so many gatekeepers involved. Some of them, like the poor librarians who've been drafted as the copyright police, to whom I referred earlier, may actually not be so problematic because they are sharers in the same educational investment, in the same educational objectives that the media literacy instructors themselves have. Others, the bureaucrats, the school system attorneys, may be harder to reach. We anticipate a nice, protracted campaign around this statement. We're looking forward to it, as has been the case before. We're looking forward eventually to a good result. I should mention also one particular formation that exists in this area, which we haven't had to cope with before, but which is going to add to the difficulty of bringing the relevant gatekeepers on board for the Media Literacy Educators Code, and that is the proliferation of sort of toxic so-called guidelines about fair use in education, which have a very sort of peculiar history and an authority within the education community that is entirely disproportionate to their shall we say, humble origins. These guidelines, the guidelines on classroom photocopying and the guidelines on the use of music and the horrible, sort of reprehensible multimedia guidelines and others have often been mistaken for law, whereas they represent merely advice or understandings of law. And even more crucially, these guidelines have been mistaken for limits on fair use, whereas they were in fact never intended as anything other than articulations of so-called safe harbor situations in which educators could, with a high degree of reliability, predict that their activities would certainly be considered fair use. The content companies have some responsibility for that last misunderstanding. They've campaigned energetically over the last 25 years to encourage the systematic misinterpretation of these guidelines as ceilings rather than, in effect, floors. But they have done so, as they sometimes do when they set their mind to it, effectively. And there's going to be a lot of good work to do in pushing back, and the code itself, in anticipation of that, addresses the guidelines problem. So I need to wind up. My time is almost over. Let me do a couple of things, though, before I stop, and that is to talk a little bit about other projects of this kind that are going on, ones that we are not directly or currently involved in, but honor and support. The Society for Cinema and Media Studies has already generated a set of guidelines with some help from my IP clinic students for classroom use of media materials, and they're on their way, again with some help from my clinic, to generating one for the incorporation of copyrighted material into cinema scholarship. The College Art Association, which is a huge and fascinating organization of working artists on the one hand and art historians and teachers on the other, has been working systematically on a statement of best practices for its membership, which will be, I think, when it is released, including, incidentally, the sort of difficult and even fraught field of art, journal, and book publishing. That's going to be an extremely influential statement when it appears. Lewis Hyde, in his capacity as a fellow of the Berkman Center at Harvard, is spearheading an ambitious new project to create one, or as it will probably turn out, several statements of best or codes of best practices for teaching in the humanities. And I'm sure that there are projects of which we're not aware that are also underway at this time. There can, of course, be more. And let me close with an observation about that, an acknowledgement, a reminder, a question, and a warning. The acknowledgement is to our financial supporters. This is at least as we've been doing it so far, a fairly intensive and even sometimes expensive activity. And the Ford Foundation and the MacArthur Foundation have been, and in the case of Mr. Ford, continue to be, terrific supporters of this work. They've made it possible, and they deserve credit for it, whether they want it or not. The reminder is associated, and that is that I don't think this work can be routinized. It is, because it is community-based work, because it depends for its effectiveness, because any coder statement depends for its effectiveness on work to first identify what a practice community's problems are and then to develop consensus within that community. It can't be streamlined beyond a certain point, although I'm certain that it can be streamlined to some extent. It can't always be rushed. It is labor intensive, which doesn't mean it necessarily has to be expensive, but it does mean that there have to be people who are willing to invest time and effort in it. And then the question with which I'm going to close. That is, what about the situation outside the United States? The fair use doctrine, as you may know, is a U.S. law specialty, just as the First Amendment is to a certain extent a U.S. law specialty. There are a few other countries in which fair use exists. The Philippines is one, for reasons that I haven't yet figured out, and although I can guess. And happily, Israel is another. Israel is the most recent country to choose fair use in the process of undertaking a stem-to-stern reform of its somewhat, or previously somewhat antiquated copyright laws. But in most places, fair use is not now a factor in the law, and other approaches to limitations and exceptions on copyright prevail. With support from the Ford Foundation, we are launching a pilot project with filmmakers in South Africa to test how the method that we've developed in the United States might be applied in a non-fair use jurisdiction, a common law jurisdiction, but one that is like the United States and like Canada or Great Britain or Australia relies instead on a related but really rather distinct concept or doctrine of fair dealing. So in a year or so, we should have something to report about the transferability of some of the methods that we've worked on in the United States to countries beyond our borders, at least those that share in our common law tradition. There's tremendous enthusiasm among filmmakers and other practice communities in Europe about this approach. But in Europe, I'm afraid, in order to bring something like the benefits of fair use to practitioners, it may be necessary not only to arrive at consensus about what good values are, but to apply that consensus to bring about actual law reform. And we begin by working with groups in Europe to help them to articulate shared values, to take ownership of those values. Eventually, I think something more is going to be required to bring the benefits of this approach to that part of the world. And that leads me to my conclusion, the warning. And the warning is about something which, gosh, I hope many of you have never heard about, but which is now a sort of cloud on the landscape, on the horizon, but appears to be coming our way. And that is the so-called three-step test of Article 13 of the International Agreement on Trade-Related Aspects of Intellectual Property, or TRIPS, which is a part of the WTO agreement. Not to go into any detail, although I'm happy to do so later, this is an old formulation borrowed from earlier intellectual property treaties, which says essentially that in order for a national law to recognize limitations and exceptions to copyright, those limitations have to satisfy three criteria, which, as they've generally been interpreted, have mainly to do with protecting the economic interests of copyright owners. This has not been a big deal in the past, because in the past it's been viewed as so many other principles are, as a kind of general admonitory feature of international law with no actual practical application in any real world national law situations. But the world is changing, as my friend and colleague Daniel Gervais has demonstrated. The three-step test is beginning to be applied both in international copyright jurisprudence as a feature of the World Trade Organization agreement that's enforceable through the dispute settlement mechanism of the WTO, and also even more ominously as an adopted or incorporated principle of domestic law in countries that are parties to the TRIPS agreement, which of course means almost everyone in the world. And the three-step test, both at the international and at the or as an assimilated standard at the domestic or national level, poses a very real risk to the survival of fair use in the United States and to the potential for the expansion of user rights and copyright to approximate the equivalent of US fair use in other countries around the world. It's something we're going to need to watch very carefully. That's an area in which we may need to get more involved in order to protect the modest but real progress that we have been making in this area. And I thank you very much. So there is a tremendous risk that the proliferation of copy protection schemes and laws that support them will compromise or limit the kind of gains in fair use that I've been describing today. There are 2 or 3 different ways of pushing back against that likelihood. And one of them is one that some of us in the room, Jack Lerner and his students and many others are right now working on, and that is, in the United States, taking advantage of the opportunity presented by Section 1201A1 of the Digital Millennium Copyright and the triennial rulemaking that it establishes. We were successful 3 years ago in achieving a small breakthrough in that rulemaking on behalf of actually cinema studies professors, thanks in large part to the terrific efforts of Peter Czerny at the University of Pennsylvania. And in the current triennial rulemaking that is underway now, we are very much hoping that other practice communities will come in and say, in effect, look, we have fair use rights here, perhaps even as evidenced by documents like this one, but we can't fully exercise those rights in this environment, so we need a DMCA exception to permit the full exercise of our fair use rights. That is, I think, one solution. It is not a perfect solution, among other things, because you have to reapply every 3 years to renew your exception. The better solution would be a legislative one. The better solution would be a solution like the one proposed in Congressman Rich Boucher's H.R. 1201, which would carve out a set of permanent DMCA exemptions for practice communities that have demonstrated their reliance on fair use. That's a US solution. I think it's within reach, although I think the time frame in which it can be accomplished is probably a sort of 3 to 5 year time frame. It is not an international solution, and the similar efforts, advocacy efforts, are going to be required under the laws of other countries which have adopted DMCA-like regimes but have not adopted similar schemes for identifying exceptions to those that exist in the United States. In some ways, those other regimes are more promising. In some ways, they're less promising than ours. There's a lot of work to be done, but I don't think it's beyond reach.
I guess when I'm choosing, I can choose myself.
So you know, sometimes people are critical of best practices precisely because they don't carry the weight of law. Mm-hmm. And I'm really heartened by your optimistic view about fair use and these you know, initiatives and institutions that are arising to support it. But is the long-term goal legislative reform, or is it a
legislative reform of fair use?
Of like, yeah,
no, like absolutely not. In my view, and I'll speak personally here because I can't speak for anyone else, the project to achieve legislative reform of fair use, which is sometimes discussed, would be, in my view, a disaster. And it would be a disaster for the following reason. For a variety of you know, for reasons that I can't quite explain. The codification of fair use in Section 107 in the 1976 Copyright Act occurred without major pushback from the content industries. And ever since 1976, the content industries have been expressing a high level of buyer's remorse about having allowed Section 107 in its present form to be enacted. Any effort to reopen Section 107 to incorporate specific carve-outs for, let's just choose documentary filmmakers to take one example, would have two deleterious consequences. One is that you might win. And that is that, and then you would be stuck with a set of time-limited, fixed, rigid, and soon irrelevant specific exceptions for documentary filmmaking. The other possibility is that you might lose, in which case what you would lose is the dynamism and flexibility of the existing fair use statute itself. So this is something about which I actually feel very strongly, and about which I differ rather markedly from some of my good friends and associates in the copyright public interest community, and I welcome the opportunity to be as emphatic as I know how to.
Great, thank you. Johanna.
Sort of a two-part question. I went to the iSummit this summer, the International Conference of the Creative Commons, an organization that I respect very much, but there was very little conversation about fair use and sort of a glazed look when it was brought up. So even if among them there's not a sophisticated conversation to be had about fair use, do we need a public education campaign? Is that where we need to spend the money, on awareness and
So it's a really good question. I want to answer it in a couple of different levels. The first is to share in your expression of admiration for the Creative Commons project and its accomplishments. The second is to give Creative Commons as a movement full credit for recognizing the potential tensions between what they're doing on the one hand and the cultivation of a fair use culture on the other. There is obviously a way in which establishing any new regime of permissions, even gratuitous permissions, is in tension with the idea that sometimes users should just be able to use without having to get permission. And Creative Commons has been wonderful in all of its publications and its announcements in acknowledging that tension and making clear that they have no wish in any way to substitute the Creative Commons mechanism for the exercise of fair use. They've been terrific about that. That said, the tension is real. Creative Commons, for many reasons, has done a much better job than the somewhat inchoate fair use movement in getting its message out. And sure, I think public relations is great, and in a way, it's what we're doing. In other words, I don't know quite how one would do a PR campaign for fair use addressed to the general public, although there may be ways. It's well beyond my competence to imagine. What I do know a little bit about is how one does it for use communities. And that's this effort. There is, in other words, a very, very strong, I won't say public relations, let's just say sort of consciousness building piece to this best practices model in the same way there is to any effective strategy of community organization.
We have time for one more question, two more questions.
I'm sorry if you choose to move on to another question after I ask this because I came late. So I don't know if I missed something. Are there any lawsuits pending or have occurred that involve the use of featured film clips in a documentary or online, or things that border on lawsuits? In other words, you have to take out the clip from a studio, a union, because somehow the filmmaker didn't pay off the appearance of our, actors, writers, directors, etc. From the music industry in particular, which seems very difficult in my experience of dealing with, to give anything for free. How's that going, and is there any pushback from?
Going great.
Pardon me?
Going great.
It's going great.
And the answer to my knowledge, no. At least where mainstream content owners are concerned. Occasionally you get sort of fringe folks who are sitting on sort of small pots of material, but mainstream content owners, for the most part, and Jaszi wants to supplement, we'll come to that.
Yeah, you're selling the best practices slightly short here because there was the Imagine case just a few months ago, which involved Beatles song Imagine in the Ben Stein anti-evolution film, and the filmmaker had relied on an insurance letter written by a local attorney here, Michael Donaldson, who I believe referred to the best practices. I could be wrong about that.
He always does, I hope.
In fact, they won.
Yeah.
They actually went to
Good
court,
point.
got a decision from the court that that was a fair use of Imagine. In the face of what is, a very sort of litigious estate, and a lot of publicity.
And the most,
It's great.
but here's,
And it is,
let me supplement this because it's such an interesting story. The case is called Yoko Ono Lennon against Premise Media Corp. It was decided in the Southern District of New York back in June of 2008. And very recently, within the last few weeks, there has been an announcement that the lawsuit has been withdrawn. There will not be an appeal. Presumably there has been some kind of settlement. And this is, in a way, part of the pattern. In other words, the last thing content owners want in general is to have these principles clarified. And the last reason they want is because they know in general, and they know better and better as a result of decisions like this one, that the clarification is likely, in most cases, to go against them. So that means that often, in general, the suits are never brought. And that in exceptional cases like this one, where the suits are brought, where the limits are tested, the content owners are backing off before a serious, that is to say, circuit court precedent is established. So it's working well, I think. And I measure that not in terms of the number of cases brought in round one, although this is a really important example, but in another more difficult way, which is in terms of the number of cases not brought. SAG and so forth is another matter. The unions are a different story. That's not an intellectual property issue, and therefore really not one that can be addressed in this way. Although I will say one thing about those claims, and that is the important thing to understand about SAG claims and equivalent union claims is that they are not IP-based claims, they are contractually based claims. Now think about that for a moment. It means, among other things, that if a filmmaker or another kind of producer has no contractual relationship with the union in question, they have, by definition, no obligation to pay. Often when you get a license to use content from its original producer, that license comes along with a secondary contractual obligation to satisfy whether their union obligations were present. If, on the other hand, you use that content to begin with as a matter of fair use, the union obligations are no longer applicable. I'll just mention that as a
member of the DG, I don't know how I feel about that.
You are entitled to feel about it any way you like, but it is the case.
Great, and since he's on the panel that's coming up and we're eating into the time, I want to get a question from Phil.
Well, okay, it might be a can of worms, but I just wanted to fill out a bit. This is a question about fair use guidelines for film stills that were promulgated by the Society for Cinema and Video Studies.
Yes,
yeah,
1992.
I used this recently. You're cited as the authority, and I thank you for that. But I recently had a dispute with Princeton University Press, about which I'll talk on the roundtable. But this morning, just kind of in preparation, I went back and looked at this thing, and I was shocked to see there's a date of 1993 at the top of this guidelines. It wasn't my memory at all. In fact, I'm not even sure I'm reading this right, but that's
You were right.
the date.
The work was done in 1992.
Yeah.
The statement, which can still be found on the SCMS website, although it's a little hard to find, it's in the archives,
I'm looking at it right
is an
here.
old document. The SCMS is currently involved in an effort to revise and update that document.
Good. Well, I mean, this is practically pre-web in 1993.
Well, that's true.
So,
And I, if I had had a little more time today, it's far from a can of worms. It's something that I'm very proud of. I would have mentioned the original. It wasn't even SCMS. It was the SCS white paper to begin with. The M was in the organization's future as the original precedent for this kind of activity, because however badly Princeton University Press is currently behaving, the fact is that the promulgation of the SCS white paper had in general an immediate and extremely positive effect on the behavior of academic monograph publishers with respect to the incorporated use of film stills. If there's backsliding going on, I'm anxious to hear about it. I'm very sorry to hear about it, and I hope very much that the new SCMS effort will sort of recapture some of the lost ground.